Welcome everyone to the fourth installment of our continuing webinar series about the intersection of generative AI, national security, and the law. Today, I'm very pleased to have the lawyers from Pitney joining us to talk about the intersection of those areas and intellectual property law. So obviously at Fluet, while we pride ourselves in being a great law firm in many areas, we often partner with other law firms who have greater expertise and experience. And in this case, we've decided to bring in our fellow attorneys from Pitney who have a wealth of experience and expertise in the area of IP law and IP litigation, an area we don't particularly focus on. So we're delighted to be joined today by Kritika Bharadwaj and Sean Park. Kritika is a partner in Pitney's technology and intellectual property transaction practice and is the chair of their AI committee. Sean is a senior associate in their IP litigation practice area. So Kritika and Sean, welcome. Thank you for joining us today. Would love to start with you both introducing yourselves.
Thank you so much, Franz. You've done a great job introducing us. I have very little to say other than the fact that we're very pleased to be here with you, and as always support Fluet in this what I would say enlightening endeavor to talk about various aspects of AI and generative AI. So thank you for having us here.
Yeah, thank you also for having us, Franz and Erica. It's really exciting time to talk about AI because as an IP litigator and copyright counselor, have been dealing with more and more AI-related issues. And also I attended a conference recently, and both the head of the US Patent Office and the head of the Copyright Office began their keynote speeches by discussing generative AI. So I would say this is a great opportunity for us to discuss these issues.
Well, great. Well, before we dive into the black letter law and the not so black letter law surrounding generative AI and IP, Kritika, how are you using generative AI, whether personally or professionally? And then Sean, I'm going to ask you the same question. I
use it quite a bit, actually. I may or may not have used it to help me prepare for this webinar. But I find it quite useful, actually. I of course don't use it for client work, but I do find it pretty useful when it comes to sort of just doing quick sort of business development or marketing kind of blurbs. To come up with sort of just help me get that first draft of something that's non-client work. I've used it actually in presentations where I've had to sort of generate some maybe images that I maybe wouldn't want to use off the internet. So that's been interesting. Recently, as Sean has seen this, but as part of the AI committee that I chair, we've been doing a bunch of training sessions for our firm members, and a lot of components of that presentation have been generated by AI, including audio, images, video as well. So we've been playing around with it quite a bit as our firm encourages it.
Great, fascinating, Kritika. Always fascinating to see her other professionals are using it. Sean, how about you?
Yeah, I'm kind of on a similar boat. I began using generative AI in connection with non-legal work. So if I'm doing a quick Google search for, say, what's the personal jurisdiction statute in South Carolina, I have tried using, for example, ChatGPT for same inquiries. Of course, I would confirm the actual law later. And I also have just been using or playing with AI tools just as a copyright lawyer. I want to be more familiar with the features before counseling clients. So, for example, I was using DALL-E to create various images containing lawyers. And kind of as a side, this is not an IP issue, but as a side note, I discovered that whenever I just asked for some images containing a lawyer, it would give me a white male lawyer. And literally the only exception was when a lawyer was actually not a person, but a dog. but the dog was still wearing a suit and tie, so maybe it was a male dog. So it's something that I noticed just as on the side.
Interesting. That's a very good example there, Sean. Kritika, just curious for you, what is the example of using generative AI that either you find you were most proud of or was most creative or most interesting for you?
So as part of my presentation, I thought this was quite funny actually. So as part of our firm's presentation, for training our attorneys and staff, I was doing one section on sort of the background and the backstory and history of ChatGPT and generative AI and how things went from, hunky-dory, everyone's excited, everyone's trying out this fancy new tool that has these cool powers, to suddenly there are these lawsuits, there are people getting into trouble, judges are asking, are catching folks who are using ChatGPT to write their briefs, and then there's a lot of focus on regulators to just regulate the use of generative AI tools, and Italy is banning the use of ChatGPT, and China does something. So there's a lot of things that goes on from a high note to a suspenseful, and then a sort of a fast suspenseful beat. So I kind of used a generative AI tool called SoundDraw, that's I think owned by Canva, to generate music that kind of plays to the tune of the feel of the situation. And I thought that was really interesting. So it starts off with like a peppy beat, and then it goes into like a suspenseful beat, and then and then sort of like, oh, let's see what's going to happen next, kind of a feel to it. So I thought that was fun. And then as part of what I was saying, I said, the judges are now asking lawyers to basically say, hey, I'm not a cat, I'm here live. And you may remember this from the Zoom cat episode. So I said, well, I'd like to have some picture to go along with it. So I asked DALL-E and a couple of other tools to generate an AI looking like a robo-looking cat that's waving and saying, hi, I'm here. And I got something that's pretty close. I thought that was kind of funny. I had fun playing around with it. It took me a lot of time, maybe much more than I needed to have spent on that presentation, but it was fun nonetheless.
Yeah, Kritika, you're bringing up the use of multimodal, right? Either putting in things other than text in and getting things other than text out, and certainly the latest wave of features and capabilities for generative AI. Well, great. Well, let's go ahead and dive into the heart of what we're here to talk about, IP. But some people are on the call are fellow lawyers that have deep knowledge of this. Other folks are potential business owners or current business owners. Other folks are probably just here because they're curious about the topic and are creators. Let's just start from a non-legal perspective or dive slightly into it. Why should I, as a user of generative AI, even care about kind of IP laws? Like, why does that matter to me at all? So, Sean, do you want to take a stab at that? You're from the litigation side, so you see the outcomes of these kind of issues.
Sure. I think we can look at it from two different perspectives. One is as a user of AI. If you're using AI to create content, whether that's writing or drawing, you want to, perhaps just use it for fun, like I was doing with DALL-E example earlier. Mm-hmm. But perhaps for your company or employer, you're using it to create some content that you want to own later on. Mm-hmm. And right now, there's somewhat of an uncertainty on whether AI created works could be protected under copyright or patent law. We'll discuss more of those details later on. But I think that the administrative agencies and courts have just relied on existing laws to decide on this brand new issue. So again, there's kind of an uncertain areas of IP law that we're certainly happy to help, but that is just a big question mark in the open. And the other way is as a user of AI, you could be exposed to risk of copyright or patent infringement lawsuits from third parties. And a lot of times these are traditional content creators whose works have been used in AI training. There are actually several lawsuits that are pending right now, for example, commenced by Getty Images or Writers Guild and so on. So while you want to protect what you create, but you also want to be mindful about others' creations while using AI.
Got it. Okay. So two broad categories. One is if you're creating content and you want to monetize it or use it for work in some way, how do you protect what you created? And then second, whether they're using it for work or not, if you're creating things with this, it may potentially open you up to some liability under existing IP laws. Okay. So that's good, broad overview of the two areas. Let's dive into the first one. So Kritika, so what are the challenges in protecting AI-generated content under existing IP laws, right? Like first, who owns the rights to this output? I'm talking to, let's use your example, right? I'm talking to Dolly. I create an image. This is awesome. I want to use this image commercially. Can I protect it? Who owns the rights to the output?
Yeah, that's I think really the crux of the whole question, right? I just a couple of days ago I asked ChatGPT. Funny story. I asked ChatGPT if it can be considered an inventor or an author of its creations, and I said, give me a funny response. And it said, oh, well, my toaster burnt a smiley face on my bread this morning. Does it make it an artist? So that's, I guess, where things are in terms of IP, right? At this point, generative AI itself cannot be considered an inventor or author of its creations, but as a user, when we generate any output, it's very important for us to know what the terms of use of these generative AI tools are, because it's in those terms of use that would specify who owns content generated by each of these tools, what you should know as a user in order to use these tools, and really what kind of input you can use. And I think universally I can say that most of these tools, generative AI providers would push the buck down to the user to confirm whether they have rights to use any content they input into the generative AI tool, as well as the provider does not want to retain any rights to the output. It's fast to give it away. So I would own rights to my AI robo-looking cat, right? But it's important as a user that I don't use someone else's IP without getting rights to it. It's also important to know that, if there are any open source licenses that are in use when generating such content, like, for example, if I were to use it to generate software, and part of that, because many of these generative AI tools might pull some code that are publicly available in the form of open source licenses. It's important for me as a user to know whether or not that generated output complies with the open source license terms and makes the required attributions and disclosures and all of that's required by these open source terms. So it's important to take responsibility as a user to know what the terms are. And to the extent I'm using it on behalf of my organization, of course, it's important for me or for anyone else using it to be aware of any policies that their employer has with respect to use of generative AI tools, or even with respect to managing intellectual property that ultimately belongs to the employer. I'd say sort of these are at least the high level top things that you need to keep in mind as a user of these tools, and especially in terms of intellectual property, right? Rights and to understand whether you're stepping on anyone else's toes.
Got it. So try to summarize, because first place you look is contract then, right? Look at what the terms of service are with the provider, look at what your own company policy is. If you're working with a client, look at what the contractual obligations are, and then open source licensing also plays into that as well. Could you follow up on that? As you were saying something, it spurred something to me. Does it matter what I put in? Like if I put in somebody else's intellectual property to produce something that comes out, does that change the nature of this analysis at all? Or is this just completely question mark? We don't know.
Well, at this point, we don't know in the sense that it's still developing. Like if you read GPT's terms of use, it will say that it assumes that you own rights to what input you're using. So if you were to use, let's say, I don't know, Starbucks logo and say, can you generate something for me which I can use as a logo for my, I don't know, pumpkin spice specifically, right? And then I want to use that commercially. That's also sort of what copyright law requires. If I'm using it just for fun, for educational purposes, you could fall under the fair use exceptions when you use someone else's copyright, or trademarks. But I mean, I guess trademarks is a whole different issue. But when you're using it for commercial purposes, then you got to be careful what you're using in respect.
Interesting. Yeah. So is the right analysis, if I'm enjoying rights that come from the terms of service, I need to comply with the terms of service in using the tool. So I can't violate the terms of service and enjoy the rights that come out of it. Is that?
That's a fair assessment and conclusion to arrive at, which is why I cannot stress on the importance of going to that fine print and clicking on it and reading what it says. Ultimately, once you get familiar with it, they'll all pretty much say the same thing, except for maybe, I saw recently, I think Google came out with a proposed policy where they said, we'll take responsibility for any of the input or the output. I don't know how that's going to play out, but it'll be interesting to see. I think it's a matter of them suggesting that, we don't want users to be, we don't want it to be a deterrent for users to use these tools. We'll take on that responsibility, but ultimately it has to, I guess Sean will see how it plays out in court when a claim actually goes to court, and Google might try to push it down to, let's see, the developer maybe, or the user maybe. Yet to be seen how that'll play out. It's hard to foresee how that'll play out at this point.
Got it. Okay. So contracts, terms of service is one. Sean, copyright. Somebody says, gosh, I'm going to copyright this thing. What is the Copyright Act and how does it apply here?
So Copyright Act protects works of authorship, which includes generally writing, music, drawing, movie, etc. The things that you can normally think of as some form of creation. The Copyright Office has taken a stance that AI cannot be the sole author of a work that is protectable under the Copyright Act. And they do so based on some old case law that talks about cameras and whether photographers could be copyright owner, because in some cases, all he or she is doing is just clicking a button, and the work is being done by a camera. And in 1900s, courts have said, well, that is true, but still there's some decision making in terms of angles, lighting, exposure, etc. So photographs can be copyrighted. And now that the Copyright Office and at least one court have applied that reasoning to say AI is not a human, which is what's generally required under the Copyright Act. The Copyright Office has come out and provided additional guidance saying that while solely AI-created work cannot be copyrighted, human-created with AI assistance could be registered for copyright protection. Now that sounds reasonable in theory, right? But the devil's in the detail in application. So there are a lot of questions that are still open, that are being answered right now. So, for example, if someone creates a work using an AI and makes modifications manually, could that be copyrighted? I think the answer is generally yes, even though in the case that the Copyright Office has addressed, they deny the application because the applicant refused to discredit the work that was done by AI. Now, there's a counterexample where we have someone who takes a photo and puts it through AI to make modifications and tries to register it. The Copyright Office has rejected that application, and we are representing the client to go through the appeal. We're waiting for the final agency appeal determination, and so eagerly waiting for that determination. And it's not something that only we're excited to hear. I mentioned the conference that I attended earlier. The head of the Copyright Office used that appeal as one of her examples in the keynote speech. So the office is obviously paying keen attention to that and other cases as well.
Wow, fascinating, Sean. Okay, I'm gonna put on my lawyer geek hat for a moment. So back in the day, there was an issue of whether photographs could be copyrighted because the work was being quote unquote done by a machine. Who was also on that suit was a bunch of portrait artists who were upset at photography, saying, hey, if you don't paint the picture yourself, you can't get a copyright on it. And so the argument ended up being no, there's still a lot of human decision making involved in taking a photo, so that photo can be copyrighted.
Yeah, I don't know if the pushback back then was from traditional artists and painters. I think the case itself involved just a copyright applicant who was dealing with that issue, although I could be mistaken about that. But nowadays, there definitely is a pushback from the traditional content creators, right? So
yeah,
these industries and academics who want to push for AI development, while some of the traditional content creators like photographers, songwriters have some of different views, and they're asking for 3 C's, which is credit, compensation, and credit, compensation, and accreditation. So
got it.
Yeah.
So interestingly, so I think you could almost approach this from 2 ends, right? The question is how much AI is too much AI that it can't get a copyright, or how much human involvement needs to be there before you can credit it? Is it the latter or the former? It sounds like it's the latter, right? We need a certain amount of human involvement for this to be. So I can't just spin up a Gen AI tool, let it just generate a bunch of images and then file copyrights for everything, right? And claim copyright. That I need to be involved as a human in the creation of that art.
Yeah, the decisions almost unilaterally say there has to be the minimum required originality that is traditionally required in copyrighted acts. So it's the certain level of human creativity that has to be present in the work to be registered. But exactly what that line is being worked out.
Got it. So yeah, go ahead, Kritika.
I guess I would liken it to an analogy is, you can't have a paintbrush be an author. It's the painter holding the paintbrush that's an author. And so I think the general consensus is that, at least amongst the Copyright Office, is that generative AI, the tool itself, is just a tool. You need to have a human behind it who would, prompt it to generate that content. And that's the human element that I suppose, that it would perhaps reward.
Yeah. So is a prompt enough human involvement? Because that's literally all it takes, right? It's a line into a generative AI tool, text to image, and now we have an image that didn't exist before, but was perhaps created using a training corpus of other people's images. What's the answer to that? Is a prompt enough human involvement to create a copyrighted act or copyrighted art image?
I would say it depends. Sometimes prompting, the more detail a prompt has, the more likely that you'll be able to protect your work with copyright. If the prompt is, say, 1 or 2 words, the Copyright Office might say that you're not doing much as a human author. Instead, the AI is doing all of the work, if not most of it. So I think, again, this is kind of one of the uncertain areas where, Copyright Office does try to provide us with examples. It's having listening sessions, presentations to kind of give us an idea. But really, I think it's where some of the cases as we go on will kind of help us draw the line.
Okay, let's, I could talk about this for like another 30 minutes. Fascinating. Let's switch over to the Patent Act. What is that, and how does that intersect with generative AI?
So patents protect somewhat different intellectual property from Copyright Act, whereas copyright protects specific expressions, whereas patents can protect broader ideas and inventions, of course. And it's somewhat similar to the Copyright Office. The U.S. Patent and Trademark Office has said that AI cannot be the sole named inventor of a patent. And they did, based on the statutory definition of the inventor, which says it has to be individuals, which the office and several courts have said means person. So we have those decisions on the books. The Patent Office has not provided guidance like the Copyright Office about human created but AI assisted inventions. But I imagine there will be kind of similar reasoning applied to those kind of work. But I think the Patent Office is generally somewhat more flexible than the Copyright Office in at least using AI in its practice. So because a Patent Office has announced that it's going to use AI to do a lot of its works, including searching for existing patents or classifying trademark applications based on the goods and services into different classes and categories.
Got it. Okay. TBD then, interesting. So this sounds very nebulous and very evolving, Kritika. So as a business then, right, that's employing generative AI to do work more efficiently, effective, to generate things, what are the strategies that a business could employ to help manage and protect their own and other people's IP, right, when they're using generative AI?
Yeah, so we've actually been advising a lot of businesses and helping them evaluate what kind of policies they should maintain at their companies. And each company is different and the policies would vary. A lot of it depends on the culture of the business, I guess the proprietary rights that the business would like to retain. But what's been consistent throughout our experience advising these companies has been that it's a collaborative effort, not just among the legal team, but among sort of the IP departments, the business departments, the administrative departments, the IT departments. It's a cohesive effort, and I'll tell you why. So when you come up, I guess the one advice would be to have a policy in place, right? Because that in the absence of any, I guess, regulation or federal state law which sets out at the moment in the US specific guidelines, I think it's for each of us to each of the businesses to come up with their own guidelines in a way that suits their business. As part of that would be to have, first of all, a clear understanding of intellectual property laws and regulations, right? It's important to understand how these third-party rights may be impacted, what needs to be done, what really is the crux of any ownership or in any IP asset. So I think that's important to understand as a business. Secondly, I talked about, understanding the contractual requirements, and these contractual requirements may flow not just from terms of use of these generative AI tools, but also from the business's obligations to their customers, right? Let's say, for example, it's a software company that's developing code and software for its clients. As part of that agreement, they are, it's all work for hire arrangements. They are developing IP that they ultimately assign to their customers, and in return for certain consideration. As part of that contract, you'll see, they would have committed to making sure that they have all rights to that IP that they create. They have, they have the right to deliver that work product to the customer. Now, generative AI plays a very important role in sort of managing this sort of a commitment by a business. If a user is generating code to which they don't have full rights to, but perhaps, maybe it's subject to an open source license, maybe it is subject to, or it contains third-party code, in which case the business is violating that term of the contract. So there needs to be policies in place to have multiple levels of supervision, perhaps, maybe even tracking and monitoring measures, which we've seen is not always, I guess, easily adopted, because on one hand, you may want to encourage employees to use generative AI tools to explore and sort of expand on innovation. But on the other hand, if you're tracking it, it may send a signal of, oh, I'm being watched every step of the way. So it ultimately depends on firm culture as to which way you want to go with that. The key to everything, though, is training. We stress so much on the fact that employees need to be trained by the businesses, and the responsibility really falls on the business, but also on the employee to attend all of these mandatory trainings, and really absorb what's being, what knowledge is being imparted. And the trainings could be anything from, training about the policy itself, training about how to use a particular tool for a specific purpose. Like I guess Sean wouldn't use ChatGPT to do case law research, right? We've all learned that. It's important to know what to use a specific tool for, and how to kind of check the output for it. It's also worth for businesses to consider collaborating at some point with the developers or the providers of these technologies, because you could potentially come up with a tool that is more specific to the business's needs. You could perhaps have the developers create a tool which perhaps would be in the business's environment, as opposed to something that's shared across multiple users, which affords the advantage of security, right? If we have an instance of an enterprise version of, say, ChatGPT or something else within the firm, we know then that the data that we upload onto that tool is likely to be more secure, because the GPT-4 model will not be learning or training from the data that we use. So you could have some separation of instances for each customer, and I think businesses would consider doing this as well. And I guess the other important thing to be aware of for businesses to take the time to do is to really investigate on what training data has been used to train that AI model, especially if you're using it for things that might cause biases, for example, like hiring tools. You really want to know how that model has been trained, and what data has been used to train it. So it's important to do that due diligence before you start using or allow your employees to start using any of these tools. And I guess lastly, I would say have confidentiality, strong confidentiality terms with whoever is using these tools, right? Your policies would stress on the fact that employees should not use confidential information or trade secrets, and should not use those in prompts. Anyone who's developing these tools specifically for the business, they would enter into confidentiality agreements as well. So businesses can do a lot to protect their not just IP, but non-IP data, as well as sort of just their rights to use these tools within the bounds of exploring within certain guardrails. But it really starts at the business level.
Okay. That's a great list of strategies, Kritika. Thank you. Sean, I think one of the things I've noticed is that a lot of folks are individually comfortable using generative AI for their own personal uses. They're less apt to use it anything that's publicly facing, and certainly anything where they're trying to monetize or commercialize it. And same thing, organizations. Internal usage is okay, but nothing that gets going to be used in a product or used for a client. And I think that was kind of the policy one of you all stated earlier within the firm. And I think that concern or that division stems from this this fear of facing some kind of IP infringement claim. So two questions then, Sean. First, is that fear real? And then second, how do we minimize or mitigate that risk at all as an individual or as a business?
Yeah, I think fear is very real. And Francis, earlier you used the word nebulous, and that's exactly where we are right now. And one example I can give is in a congressional hearing, I believe before the House Judiciary Committee, one of the panelists was a former general counsel of the Copyright Office, and he said, in his opinion, he believes AI training is likely considered fair use, which is a defense to copyright infringement claims. A few days later, a different former general counsel of the Copyright Office published an open letter saying he does not agree with that statement. He actually believes that AI ingestion is likely not a fair use. So you can notice immediately that they're not even using the same word, right? So there's a drastically different view between these two highly sophisticated and well-informed copyright lawyers. So right now, there's a lot of uncertainty out there. So the fear, I would say, is very justified, especially when you're using AI to create some content or work product for a company. And I think the best way to really anticipate or address potential risk is to just stay updated on these developments. We mentioned there are currently no express regulation or legislation on these issues, but there are court cases that are coming out. And there's, like I said, there's a lot of congressional hearing, public listening sessions before the administrative agencies on these issues. So, we're gearing up to something. Exactly what, we don't know. There are more than, I think, a dozen proposed legislations concerning AI for the moment, and there'll probably be more. Which of those will be actually enacted, we'll just have to see and stay updated.
Okay, so nebulous, unclear, be careful, stand by, consult your lawyer. Okay, Kritika, what if stuff I'm using is open source? It's an open source model, there's an open source license. Am I off the hook? Am I good? This is free and clear, right? It's open source.
Oh, definitely not. The most basic requirement of open source licenses is that the license needs to be attributed. So it's really important that the output that's generated reflects the fact that an open source code has been utilized in generating that code. And we've actually seen an example where ChatGPT in its initial days had wrongly identified the name of the license. And if you search for examples of that, you'll find it on the internet. But there were examples of ChatGPT getting the license wrong, or just making up. There was one example where it just made up a license that did not exist, which was quite bizarre. So things like that could really get someone in trouble. The interesting part about using open source licenses is it's all publicly available, right? So there is no way to, well, there might be ways in the future to limit generative AI tools from utilizing open source licenses. No, not anything at this point, but you know, to the extent it's used, then attribution, disclosure that open source license has been used, you might have to under your contracts with customers or third parties, be required to disclose the fact that open source licenses, or even you might be prohibited from using open source licenses. So that kind of one needs to be careful that they're not triggering any violations under contracts in instances like that. And I think another kind of issue when it comes to using code, using output that potentially might have open source licenses, I think the question of, have you really created sort of like a derivative work? Has it been transformative? Are you generating content or generating code that could have its own copyright protections? Is one of the bigger questions that one would need to assess when using generative AI tools that include open source licenses.
Got it. So we've mentioned this a couple of times, and I'm mindful of times. We're going to have to wrap up here shortly and go to Q&A. So if you go into an image generation platform or a large language model, I can ask it to generate something and then put in the style of, and I can insert the name of the author, the name of artist. That, while cool to me, it always seemed like, gosh, if I was that artist or that writer, I would not be happy with this, because clearly they had to use my intellectual property, right, to create the ability for this generative AI model to emulate my work, right, either my style or my writing or my art. You know, Sean, help me understand, like, there's this idea of derivative works and transformative works, and how does this factor in?
Yeah, so that's a very complicated question, I would say, and I guess I'll start with this. So copyright law protects expressions instead of ideas, and it's generally, you can just think of it as a level of detail. So the more detail you contribute to a work, the more likely it can be protected. But if all you have is like the earlier example, just a simple idea, in the broadest sense, that in itself is not enough. I think a lot of the examples we're talking about is similar in that sense, in that, you know, if you're asking an AI to create something just with the simplest idea, that's probably not enough for protection. Now, on the other side, if you're telling an AI to just use some style that's really broad, that probably is not enough to be liable under the Copyright Act, right? For example, if I'm asking ChatGPT to come up with a poem that's based on, say, the 16th English style, 16th century English style, that's probably okay. But if I'm asking a really specific prompt, like, please give me a scary story that's based on, or that's like, you know, Stephen King's Carrie, maybe that's too specific, right? You're providing a specific input to AI. So I think, again, it goes back to the level of kind of amount of detail that you provide to AI, to the extent that a work is properly created, even based on something, a derivative work can be separately protected under the Copyright Act. And depending on what it was used to create that derivative work, you may be able to claim copyright to that derivative work. So, for example, if I'm using some truly old painting that's in the public domain, that's not anyone's copyrighted work anymore, to create something else, I can claim copyright to the new creation based on the additional elements that I contributed to that work. Now, of course, it comes to the question of what exactly did how did I use AI to add that element? That becomes again the issue of whether the work can be registered for copyright or protected under the Copyright Act.
Got it. So let's say, so more concrete example. Let's say I'm opening up a brewery and I want to use generative AI to create a beer label, right? So, what kind of guidance would you give, Sean? What is completely safe? What is pushing up against the line? What is over the line in terms of using generative AI and potentially violating somebody else's IP rights?
So I would say the safest example is providing providing very detailed prompt that is novel and not strictly based on some third party's IP to come up with something new. Now, the question is going to be whether it's going to be purely AI created or created by human with AI assistance. So maybe another additional step that you can take is AI makes something based on your detailed prompt, and you do additional work to make modifications so that even if the first thing is not considered copyrightable, the second thing that you made additional changes to could be protected. So I think that's the safest route. And of course, document the steps that have been taken so that if there's any question that you can go back and point to these evidence. I think it becomes a little trickier when you're using an existing work of a third party and you're asking AI to make changes on that. Now that gets into some of the kind of debatable or litigatable issues where a third party could point out and say, hey, you're using my copyrighted work. So an example I can give is I think that Getty Images has sued a graphic AI company because they were able to create an image that contains the Getty Images logo in the image. They probably have gone through, I don't know, thousands or millions to finally arrive at that image, but they did get one, and they were able to sue the AI company based on the copyright and also trademark infringement for the use of the logo. So I think I think it goes back to the point earlier that even if you're using third-party IP, even using third-party work in a way that's not using their IP but creating something else, I think it's always better to add sort of a human element after the AI's done its job, so that you can always say, regardless of what's happened before, I have at least added these and these elements to it.
And I would also advise you to keep a record of all of your prompts and any background work that you would have done, because ultimately you need that record to show all the steps you've taken to originate or create that work product.
Got it. Okay, let's switch over. Erica, do we have any questions yet from attendees?
No attendee questions at this time. You all were very well prepared. Okay,
I will ask a question which kind of strides across all the lines. Two questions. Could an AI win the Nobel Peace Prize, right? Or a Nobel Prize for like a scientific advancement? Or two, could a human who told AI to do something and then it came up with a novel invention or the peace plan win the prize, right? And third, what would a human being have to do then to use AI to win the Nobel Peace Prize? How much involvement? So those are three separate but related questions.
Wow, I don't think the other Nobel Prize winners would be happy about this if a generative AI tool were to win a Nobel Peace Prize. But I know, I think Sean would have the right answer to this, suppose. But
yeah, and maybe Peace Prize is too far off there, but I will give you an example. So proteins, okay, there are actually a large number of proteins that do interesting things, and one of the things chemists are doing now is using generative AI, I know this for a fact, to generate new protein structures that never existed before, and then they're literally just testing to see what they can do, right? There is no human being that is actually creating the protein structure. They are feeding in training data of other interesting protein structures, and then a protein structure is coming out, and then they discover the uses for it, right? Imagine if one of those protein structures cured cancer, right?
yeah,
Yeah.
We know a lot of healthcare companies are using generative AI tools to do exactly this, right? And I think based on what we've covered today, at least the way things are as of today, there isn't a law as of now that prohibits companies from using a tool to do this kind of play this role in developing a cure for cancer, let's say, for example. Can they protect it as a patent? At this point, yes, and potentially yes, depending on how I saw Sean go, ooh. But can the AI model itself be the inventor? Definitely not at this point. And I don't see in the future it would go that way either. But can the company or the employee or the inventor claim authorship to that, I guess, invention, if you're talking about patents? I suppose so, is what I'm going to say really slowly, but to the extent that, they have sort of taken step. I don't know, I'm struggling to say yes or no, because I'd then be playing the USPTO, but it'll be interesting to see where it goes for sure. Will we see people making applications? Definitely, because that's where things are going. But if I were to look at it in an oddball, I would say yes, there will be a day when potentially when inventors could claim rights to something that they've generated using a GenAI tool. At the end of the day, I would still look at it as, the idea of coming up with this concept or end result was ultimately still human. They used a tool which could very well be some other software that was doing some computation analysis or whatever it is. It's just a different form of a tool. So if I were to look into the future, I might say, yeah, that inventor could potentially be a patent owner. But will that AI tool be the patent owner? I don't think so, and I also hope not.
Yeah, Sean, I'm curious your legal analysis, because if someone were to use generative AI to come up with a cure for cancer, that's $1 trillion product, right? Everybody else would want to argue there is no copyright here, so they could mass produce it themselves. Obviously, the person who used generative AI would like to be able to claim complete control over that invention. What are the pros and cons?
Yeah, I think you would certainly want to incentivize inventors to come up with new ideas, and that's exactly. That's the very reason we have patent law and copyright law, right, under the Constitution. So I think there's got to be some kind of balancing act. In the example that we were just discussing, I think I agree with what Kritika was saying. Right now, it's even when AI is doing a lot of the work to come up with designs, there's got to be also a lot of human involvement. And under the patent law, the requirement is the definite and permanent idea of complete and operative invention. And I think maybe AIs nowadays is not quite there to achieve that step. But in perhaps a few years, AIs would be advanced enough to be able to do all of those, and maybe even more, so that you couldn't really say there was enough human involvement in coming up with that protein molecule, and that technically based on the existing law and case law, we may not be able to patent that. But that that's where it'll be up to the Congress and the Washington community to come up with a new policy, perhaps, to promote or continue to promote these kind of innovation and advancement. I'll just use another example here, which is copyright, but I think still relatable. The Copyright Office published a notice of inquiry a couple months ago on these various AI issues. And as of yesterday, there have been 9,000 comments submitted. And I believe that's pretty high and unusual, especially for IP issues. So there's just a lot of focus on it. And I think, like we said earlier, right now there's somewhat of an uncertainty to exactly know where we're going to go. But once we do know where we're going to go, and if the community or the public doesn't believe that's the right direction, we'll have to make a change to continue to promote, incentivize inventions, while at the same time allow these advancements to be made available to the public.
Great. Well, Sean and Kritika, this has been an incredible conversation. You both have been fantastic. I've learned a thing or two and more. Thank you for sharing your time, your experience, your expertise with us. I assume that somewhere in the notes and the email we sent out will include your contact information, include our listeners, in case our listeners want to follow up with you. Thank you both. I'm going to turn it over now to Erica for a wrap-up.